today. I appreciate
Thank you so much
that a lot.
for your willingness to talk with me.
Have a seat. So are you from this area?
No, not originally.
Where do you come from?
I'm from the East Coast.
And do you have brothers and sisters in this area? Or?
I do have family in this area.
Okay. And who passed away in your family?
My uncle passed away of multiple myeloma.
Okay. Had he had it been a long illness?
It seemed long to me.
Yeah. Were you helping to care for him?
I tried.
Yeah. That's a job, isn't it?
It is a job.
Yeah. Well, do you have his original will with you?
No, I'm sorry, I don't have it with me.
Okay. And are you going to be able to get the original will for me?
Yes.
And a death certificate? Okay.
Yes, I can do that.
All right. The thing that we need to decide early on is when we're looking at his assets, we need to make a determination which of them are probate assets and which of the assets will move to where they want to go without going through the probate process. So when you look at bank accounts and real estate, that sort of thing, if they're joint tenancy or payable on death, IRA, beneficiary, those aren't going to be assets that we'll deal with in the probate process that you and I are going to talk about, okay? But if you look at an asset and his name is the only one on there, then you're going to have to figure out how to be empowered to legally manage that and administer that asset. So that's what we're going to be looking at as you progress through serving as his executrix the process, because that title is going to be stuck there until you figure out how to have the power to sell it or keep it or just do whatever you want to do with it, okay? So what I want to talk about are the three different phases of probating an estate, okay? And the first thing that I need to tell you is that anything that you ever say to me in this office is absolutely confidential. When we get all through today, if you are feeling comfortable that I would be a person that you'd want to work with, we're going to sign a fee agreement, and it'll explain very clearly what fees will be for me, and you're entitled to receive a fee as well, and we're going to ask you to get a calendar. In fact, our staff has a calendar that you can use to keep track of your time and what you do in the event that you make a decision to ask for a fee as well.
Okay.
So when we get through with this discussion, if you want me to help you with, that will be our first step. Okay. Then what happens is I prepare any number of pleadings, and the purpose of that is to get you to sign them, and I go to court and I ask a judge to approve the validity of the will and then to name you as the executor. Once that's done, the court issues this piece of paper called letters testamentary, and that is the piece of paper that empowers you to take care of his affairs, okay? And at the same time, you get something called an order of solvency, which allows you to do almost everything you need to without having to go back and forth to court and get orders. So it's a very streamlined process in the state of Washington. That's phase one, okay? The next phase belongs to you. Your job will be to identify assets, gather assets, value assets, send out a notice to creditors and determine who's owed money. And when we find out the assets that you have and who's owed money, then we can match up to see, number one, that we have a solvent estate, and secondly, that you need to figure out how to get enough money to pay the bills. And once you've accomplished that, and a minimum of 120 days have passed, you can begin to think about closing up the estate. So the key administrative piece in the middle of it is your job. So how do you feel about that? Do you think that you have the time and the interest and honestly the administrative ability to take care of that phase of the estate?
Seems like a lot, but I hope I can do that with your help.
Yeah, you know, and that's really a good question, because what we do when we're probating is that we believe that our clients are very capable of doing many things we don't believe that a lawyer has to do everything for a client, number one, because it's more economical for us if you do work that you're capable of doing. And secondly, we will help where we can, so together we can move this thing forward. That's kind of the team effort that we try to work with when we're assisting people in probating estates. Okay. So once we get you through the middle phase, assuming everybody's happy, I guess, all the heirs. Now, you mentioned that there's 4 of you, there's 4 heirs, is that what you said?
I believe so.
Okay. So once you get everything managed, it's time to distribute. The process is abbreviated, and you do it with a document called a Declaration of Completion. And that's a very summary statement of everything that you've done. You don't go to court to close an estate unless one of the heirs, after you give them a declaration and a notice that you're completed, you don't have to go to court before a judge unless somebody asks for a full accounting. And if that happens, then it's a very complex, involved process. In most cases, if you've been working well with everyone, the process is done in a very abbreviated fashion, and either 30 days pass when they can ask for an accounting, or they waive that 30 days, then you can distribute the funds, you get a receipt, you get discharged, you've done your job. So that's what the probate process looks like.
Okay.